Hello everybody, this is Brandon McGee at the McGee Law Firm, and today we are going to talk about a special kind of probate called probate as Muniment of Title only. Now before we discuss that, let me remind you that I am a Texas lawyer. I'm in the DFW area, so what I'm going to talk to you about only applies in the state of Texas as far as I'm aware. Maybe it applies in other states, I don't know, but that we are going to be discussing Texas specific law today. So probate is Muniment of Title. What is that? It's kind of a funny sounding term, right? It's a very old-fashioned term, and it is a way to go through the probate court that is with a last will and testament that is quicker and less expensive than doing what we would call a full-blown probate where somebody is appointed as an executor at the end of the process. Now, how come everybody doesn't do probate as Muniment of Title only if it's quicker and cheaper generally? The reason is because it only applies in very certain specific situations. And the situation is this: if somebody comes to see me, let's say a wife and her husband has passed away, and number one, he has a valid last will and testament, so we need a valid last will and testament. Number two, the only titled asset that the wife needs to get the husband's name off the title from is real estate, okay? So if there's financial accounts, 401k, bank accounts, in this circumstance, the wife would already have access to those, maybe through death beneficiaries or being a joint account holder. But if the only titled asset the wife can't get to or clear the husband's name off the title is real estate, we can use Muniment of Title. Also, there can be no debts existing against the estate. So this has to be a decedent who doesn't have a bunch of credit card debt and things like that, or legal judgments floating around, okay? So if that scenario fits, we have a last will and testament, it's valid, we have no debts, and real estate is the only titled asset that we're gonna go after here, that we need to go after, we can do probate as Muniment of Title only. It is quicker, it is cheaper, and it does not appoint the executor. The court never appoints an executor at the end of the process like would normally happen. What happens is the court takes judicial recognition of the beneficiaries in the last will and testament. So the court would see that, okay, the wife is the beneficiary. This is a valid last will and testament. The court would write an order to that effect. That gets filed with the copy of the will with land records. And when that happens, when that court order gets filed with land records, the wife becomes the sole owner of the property, and effectively speaking, the husband the deceased husband is out of title. Okay, so that's just something for you guys to remember whenever you may have to go through probate with a friend or a family member. And please always reach out to us when you have questions about these videos. We do offer a complimentary consultation. The first hour of my time is always complimentary to any of you guys or you and your family. So please feel free to reach out to us anytime. Thanks, guys.